Excellencies, Honorable Justices, distinguished guests, ladies and gentlemen, a very, very good afternoon all the way from Indonesia, and a warm welcome to the second conference of the Judicial Conference of Constitutional and Supreme Courts Councils of the OIC Member Observer States, J-OIC. We have arrived at the final day of our conference, which began beautifully today with our delegates here in the city of Bandung exploring more of the historical sites of Bandung, delving even deeper into its history, such as visiting the Museum of Asia Africa, which bore witness to the Conference of Asia Africa dating back 66 years ago, the very conference that shares the same spirit, the same principles with our deliberation today, and exploring more of the beautiful corners of Bandung city, savoring all of its beauty. And we also extend our warmest welcomes to all of our virtual participants out there, wherever you are, joining us from different parts of the world, from different time zones. We have 33 countries joining us for the conference, and special appreciations we extend to the observer states of J-OIC, our colleagues in Russia and Thailand, as well as non-member states Korea. We truly appreciate taking your time and joining us for the conference. And to our virtual participants today, we also kindly remind you to please follow the naming format that has been advised by the Secretariat. That is the name of your country or institution or organization first, and then dash, and then your name. So once again, to our virtual participants, please do follow the naming format that has been advised by the Secretariat. Your country or organization first, dash, and then your name. And to all of our delegates and participants, please also submit your responses and feedback to the draft of Bandung Declaration before the end of session 4 today. And now, Excellencies, Justices, ladies and gentlemen, we have arrived at session 4 of the conference. 5 esteemed speakers will deliver their presentations. Allow me to introduce from Pakistan, Chief Justice of the Supreme Court of Pakistan, His Excellency Gulzar Ahmed. From Russia, one of our observer states, Justice of the Constitutional Court of Russian Federation, His Excellency Gadiz Goziev. From Bangladesh, Chief Justice of the Supreme Court of Bangladesh, His Excellency Sheikh Mahmoud Hussain. From Cameroon, Justice of the Supreme Court of Cameroon, Her Excellency Marie-Louise Abomo. And from Palestine, President of the Supreme Constitutional Court of Palestine, His Excellency Mohammed El-Haj Kachem. And session 4, ladies and gentlemen, will be chaired by our very own Justice of the Constitutional Court of the Republic of Indonesia, His Excellency Manahan MP Sitompul. May we invite Your Honor to please proceed and take your seat at the chairman table. Ladies and gentlemen, this is session 4.
Good afternoon, ladies and gentlemen, distinguished all participants. May peace be all for all of us. First of all, please let me extend my greetings to all of you, respected delegates that participate in this conference. I would like to thank you for making the time to contribute to this conference by sharing valuable knowledge and experience. I have the honor to be the chairman of the 4th session of the J-OIC Conference today, which is also the final session of the conference. There will be 5 speakers from Pakistan, Russia, Bangladesh, Cameroon, and Palestine, who will be representing their respective institution. I truly believe that each speaker will share valuable knowledge and experience, giving us a new perspective on this subject. Without further ado, let us begin this session with the first speakers. His Excellency Gulzar Ahmed, Chief Justice of Supreme Court of the Islamic Republic of Pakistan. The floor is yours.
Bismillahirrahmanirrahim. Assalamu alaikum. His Excellency Mr. Anwar Usman, Chief Justice of the Constitutional Court of Republic of Indonesia. His Excellency Mr. Zoto Arsalan, President of the Constitutional Court of Republic of Turkey. Organizers of the Second Judicial Conference of Constitutional and Supreme Court Councils, representatives of all countries participating virtually, ladies and gentlemen. It is a great pleasure to be here before you today as Chief Justice of Islamic Republic of Pakistan. In an increasingly interdependent and interconnected world, the continuous interaction of institutions of various countries in the faces of unprecedented challenges and adversities is felt greater than ever, especially after the outbreak of coronavirus pandemic. I appreciate the General Secretariat of the Organization of Islamic Cooperation and also the Constitutional Court of Republic of Indonesia for holding this judicial conference, which will be a big step towards achieving the goal of supremacy of Constitution and protection of human rights in the Islamic countries. The Organization of Islamic Cooperation is rightly so and collective voice of the Muslim world. With the rise of Islamophobia and hate crimes against Muslims across the world, the role of this organization has become more important than ever. I also appreciate greatly the call of General Secretariat of the OIC to raise voice against the gross violation of human rights around the globe. The topic for today's conference, Human Rights and Constitutionalism, the contribution of judiciary in Muslim countries, which relates to how the court can promote and protect human rights. The sub-themes are lesson learned, the role of judiciary to promote humanity and democracy, and protection of social, economic, and cultural rights and pluralistic society. The conference will shed light upon how the judiciary of Muslim countries promote humanity and democracy, and how protection of social, economic, and cultural rights and pluralistic society can be achieved. The question is, what are the basic human fundamental rights? The basic accepted characteristics of the human rights are that of human rights are universal and belong to all individuals, irrespective of their religion, ethnicity, gender, or sex. They are absolute and innate, not grants from states or some authority. They are the properties of individual subjects who possess them because of their capacity of rationality, agency, and autonomy. It is often alleged by the West that the basic human rights are not compatible with the injunctions of Islam, which do not provide many rights to the minorities. All the human rights stem from the basic principles of dignity and equality. To negate the above allegation, it is sufficient to mention that the Allah Almighty has ordained in the Holy Quran that, O mankind, we created you from a single pair of a male and a female and made you into a nation's tribes, that ye may know each other, not that ye may despise each other. Verily, the most honored of you in the sight of Allah is he who is the most righteous of you. Here, Allah Almighty has not addressed only to the Muslims, rather to the whole mankind, both male and female, and only the yardstick to gauge the status of a human being is the righteousness. In the last sermon, the Holy Prophet Muhammad sallallahu alaihi wasallam has mandated inter alia that all mankind is from Adam and Eve. An Arab has no superiority over a non-Arab, nor a non-Arab has any superiority over an Arab. Also, a white has no superiority over black, nor the black has any superiority over white, except by piety, taqwa, and good action. Return the goods entrusted to you to their rightful owners. Hurt no one, so that no one may hurt you. Remember that you will indeed meet your Lord, and that he will indeed reckon your deeds. Do treat your women well and be kind to them, for they are your partners and committed helpers. And it is your right that they do not make friends with anyone of whom you do not approve, as well as never to be unjust. Therefore, both the principles of dignity and equality of mankind, which are the basis of human rights, are protected in Islam. Islam also ensures protection of right to life and liberty, freedom of belief, right to justice, right of women, including equality, inheritance, education, business, and to indulge in political affairs. With regard to the issue of minority rights, I may mention here the words of our founding father, Quaid-e-Azam Muhammad Ali Jinnah, who in first presidential address to the Constituent Assembly on 11th August 1947 assured that you are free to go to your temples, you are free to go to your mosque, or to go to any other place of worship in the state of Pakistan. You may belong to any religion or caste or creed that has nothing to do with the business of the state. In March 1949, the objective resolution was passed by the Constituent Assembly of Pakistan, wherein it was resolved to frame a constitution for the newly sovereign independent state of Pakistan, which will guarantee that adequate provision shall be made for the minorities to freely profess and practice their religion and develop their cultures, and fundamental rights would be guaranteed, including freedom of thought, expression, belief, faith, worship, and association, subject to law and public morality. The framers of the Constitution adopted the above ideals resolved in the objective resolutions, and in the true perspective, in that in the preamble of the Constitution of 1973, the above principles were also kept at the forefront. In addition, various fundamental rights were provided to the minorities, including freedom to profess religion, to manage religious institutions, Article 20, safeguard against taxation for the purposes of any particular religion, Article 21, safeguard as to educational institutions in respect of religion, etc., Article 22, equality of citizen, Article 25, non-discrimination in respect of access to public places, Article 26, and safeguard against the discrimination in services on the basis of religion or caste, Article 27. Besides, under the principle of policy, it is mandated that the state shall be safeguarded to safeguard the legitimate rights and interests of minorities, including their due representation in the federal and provincial services, Article 36. Article 51, 59, and 106 of the Constitution provide for a quota of reserved seats for non-Muslims in the National Assembly, Senate, and the provincial assemblies. Besides, quota has been provided to the minorities in the government services. The minorities have full opportunity to engage themselves in any business or profession. Even some of the top businessmen belong to the minorities in Pakistan. Article 25 of the Constitution of Pakistan that all citizens are equal before law and are entitled to equal protection of law. And there shall be no discrimination on the basis of sex. However, it shall not prevent the state from making any special provision for the protection of women and children. Article 27 provides that no citizen otherwise qualified for appointment in the service of Pakistan shall be discriminated against in respect of any such appointment on the ground only of race, religion, caste, sex, residence or place of birth. Besides, Article 34 of the Constitution mandates full participation of women in the national life, and Article 35 mandates that the state shall protect the marriage, the family, the mother, and the child. In order to ensure the representation of women in the government, Article 51, 59, 106 of the Constitution provide for a quota of reserved seats for women in the National Assembly, Senate, and the provincial assemblies. Besides, quota has been provided to women in the government services. Thus, the Constitution of Pakistan guaranteed equal opportunities to the woman to take part in every sphere of life. The Constitution of Pakistan also ensures that the right to education by mandating in Article 25A that the state shall provide free and compulsory education to all children of the age of 5 to 16 years in such manner as may be determined by law. As the guardian of the Constitution and protector of the fundamental rights of the Pakistani citizens, the Supreme Court of Pakistan have always safeguarded the rights of minorities. The Supreme Court under Article 184(3) of the Constitution, upon a letter received from an NGO regarding a bomb blast in a church in Peshawar city and threats being made to other religious minorities, took so motu notice and in its judgment, while interpreting the scope of Article 20 of the Constitution, held that freedom of religion must be construed liberally to include freedom of conscience, thoughts, expression, belief, and faith. It pointed out that the freedom of religion has both individual and community-based connotations, thus giving the right a wide interpretation. The court, in this celebrated judgment, directed to constitute a task force with the aim of developing a strategy of religious tolerance, appropriate curricula to be developed at school and college levels to promote a culture of religious and social tolerance, and directed the federal government to take appropriate steps to ensure that hate speeches in social media are discouraged and delinquents are brought to justice under the law. The National Council for Minorities' Rights be constituted, a special police force be established with professional training to protect the places of worship of minorities. A one-man commission was constituted by the Supreme Court to consider all aspects regarding the implementation of this judgment of the court. During the implementation proceeding of this case, the burning of a Hindu temple at Karak, Khyber Pakhtunkhwa, was brought to the notice of the court. The court directed to arrest the culprits and immediately start construction work at the site to restore the temple in its original form. On 11 June 2021, it was brought to the notice of the Supreme Court that in Karachi, the land of a dharamshala, but the same was being demolished. The court immediately stayed the demolition of the building and directed the Commissioner Karachi to take over the said building for its protection and preservation. On 5th August, it came to the notice of the Supreme Court that the Hindu temple in Rahim Yar Khan, Punjab, was attacked and damaged by an angry mob. The Supreme Court of Pakistan, I as the Chief Justice of Pakistan, fixed the matter for hearing on the very next day and issued strict directions to the government to arrest and bring to justice all concerned people. The government was also directed to reconstruct the Samadhi and temple and take measures to restore the atmosphere of peace and harmony among all religious and cultural sects. The Supreme Court takes the fundamental rights and freedoms of all citizens of Pakistan seriously and sincerely. We have been at the forefront of ensuring that no unfairness, atrocity, or violation of rights of public take place. Whenever any instance of violation of fundamental rights has been brought to the notice of the Supreme Court, it never hesitated to take up the issue and rectify the wrong. Starting from the case of forced bonded labor at brick lanes, D.N., the Chief Justice of Pakistan, on a telegram received from a brick lane worker named Darshan Masih, took suo motu action and held that the form of work in a brick lane was forced labor and not permissible. This case paved the way for the Bonded Labor Abolition Act 1992. In another historic judgment, the Supreme Court gave wide interpretation to the right of life enshrined in Article 9 of the Constitution of the Islamic Republic of Pakistan. The right has been held to cover all facets of human existence and included all amenities and facilities which a person born in a free country is entitled to enjoy with dignity, legally and constitutionally. It also reiterated the very basic and intrinsic principle that the constitutional rights, including the fundamental rights, were higher than legal rights conferred by secondary legislation. In a similar case, the Supreme Court upheld the rights of people to have supply of clean and unpolluted water. In a widely interpreting the scope of right to life, the Supreme Court held that impure food items also fall within the category of deprivation of life. In another case, the Supreme Court held that the public park, if is earmarked in a housing scheme, creates a right amongst the public, and that the right includes their entry in the park without any obstacle, being fundamental right enshrined in Article 26, read with Article 9 of the Constitution. There are hundreds of such cases where the Supreme Court of Pakistan has ensured protection of fundamental rights of the people. Recently, in a case, the Supreme Court has held that right to pension had a constitutional significance. It drew its strength from the right to life or the right to livelihood under the Article 9 of the Constitution. In another case, the Supreme Court has held that every person is entitled to all rights and freedoms set forth in the Constitution without distinction of any kind. Therefore, it applied equally to persons with disabilities, guaranteeing them full enjoyment of their fundamental rights without discrimination. Even the Supreme Court of Pakistan has contributed greatly in ensuring the constitutionalism and democracy in the country, starting from Doso's case in 1958 till Sindh High Court Bar Association case in 2009. The Supreme Court has evolved as a true custodian of the Constitution and protector of the democratic norms. Although in Doso case, the Supreme Court had validated the supra-constitutional action of a dictator, but in Asma Jilani's case, it overruled the Doso's case and declared the then military dictator as a usurper. Even thereafter, whenever any supra-constitutional action was taken in past, the Supreme Court tried to restore the democratic system in the country. In 1977, General J-OIC did not abrogate the Constitution but made certain amendments to the Constitution of Pakistan 1973. The Supreme Court legitimized the actions, but it paved way for restoring of democratically elected government after the general elections of 1985. In 1999, when General Pervez Musharraf imposed emergency and held in abeyance some portion of the Constitution, Supreme Court validated the action but directed that the fresh election must be held within 3 years, and in this way, the country would return to the democratic setup. In 2007, again, supra-constitutional steps were about to be taken. The Supreme Court issued a restraint order against any such steps and ultimately declared all such actions to be ultra-vires the Constitution and consequently being illegal and of no legal effect. This judgment of the Supreme Court has practically put to an end the supra-constitutional actions and ensured the supremacy of the Constitution and rule of law, besides continuous democratic rule in the country. In this manner, the judiciary of Pakistan has played a vital role in the constitutional development and promotion of humanity and democracy in the country. The judiciary of Pakistan is committed relentlessly to continue and take all necessary action against any violation of human and fundamental rights or deviation from the Constitution. Thank you very much.
Thank you, Guljar Ahmed, from the Supreme Court of the Islamic Republic of Pakistan for the presentation. I noted as a simple conclusion from your speech that Islam as a religion protects and highlights the principles of dignity and equality of people, and that human rights is something that is taken seriously. Judiciary of Muslim countries is and shall always be in their work to promote humanity and democracy for all citizens. Thank you for your effort. Now, let's continue to the next speaker from the Constitutional Court of the Russian Federation, His Excellency Gadis Galgiev. The floor is yours, please.
Ассаламу алейкум. В первую очередь я хотел бы от имени Конституционного суда Российской Федерации выразить благодарность за возможность присутствовать на второй конференции конституционных и верховных судов Организации исламского сотрудничества.
Dear colleagues, first of all, on behalf of the Constitutional Court of the Russian Federation, let me express gratitude for the possibility to attend the second conference of Constitutional and Supreme Courts of the Organization of Islamic Cooperation.
Участие в данной конференции очень ценно для Конституционного суда Российской Федерации. Россия многонациональное и многоконфессиональное государство, а потому для нас очевидна важность согласования различных ценностей, которые представляют цивилизации Востока и Запада, поиска компромисса и площадкой для диалога.
Participation in the conference is valuable for the Constitutional Court of the Russian Federation. Russia is a state of many ethnicities and many religions. Therefore, we clearly recognize the importance of reconciliation of different values represented by civilizations of East and West to find compromise and grounds for dialogue.
При этом мы неоднократно убеждались, что правовая основа мусульманского мира в измерении прав человека основана на достоинстве, милосердии и сотрудничестве.
We have had many opportunities to see for ourselves that the legal basis of Islamic world in terms of human rights is based on dignity, mercy and cooperation.
На этом указывают многие исследователи правовых систем ислама, включая работы шейха Мухаммада аль-Газали.
Rightly, many Islamic legal scholars, including Sheikh Muhammad al-Ghazali, rightly point out this.
Достоинство человека как правовая ценность пронизывает и Конституцию Российской Федерации, а также многие международные договоры.
Human dignity as legal value is embodied in the text of the Constitution of the Russian Federation, as well as many international treaties.
Таким образом, эти основания для признания и защиты прав человека можно назвать универсальными, своего рода фундаментом совести человечества.
Therefore, one can surely call this basis for recognition and protection of human rights universal. They can be perceived as fundamental for conscience of humanity.
Понятным и мусульманским, и христианским, или светским государствам.
They can be equally understandable for Muslim, Christian, or secular states.
При этом они обрели правовое измерение сравнительно недавно. Я вряд ли ошибусь, если укажу на вторую половину XX века как время расцвета юридического закрепления достоинства личности.
At that, they acquired legal, juristic dimension fairly recently, I will hardly be wrong to name the second half of the 20th century as the time when legal definition of human dignity flourished.
Однако и до этого наши отцы придавали данной ценности большое значение, в том числе основываясь на религиозных положениях.
But even before, our forefathers attributed large importance to these values, largely due to religion.
В прошлом году в Конституцию Российской Федерации были внесены дополнения, и появилась статья, в соответствии с которой Российская Федерация, объединенная тысячелетней историей, сохраняя память предков, передавших нам идеалы и веру в Бога, признает исторически сложившееся государственное единство.
Last year, additions were introduced to the constitution of the Russian Federation. A norm appeared, according to which the Russian Federation, united by the millennium history, preserving the memory of the ancestors who conveyed to us ideals and belief in God, as well as continuity of development of the Russian state, recognizes the unanimity of the state that was established historically.
Универсальный характер прав человека открывает широкие перспективы для диалога и сотрудничества. В этом процессе, конечно, исключительно важное место играют конференции судебных органов, прежде всего высших судебных органов, поскольку они прямо уполномочены на осуществление защиты прав человека, в равной степени уважая как политические, личные, так и социальные права.
Universal nature of human rights opens great perspectives for dialogue and cooperation. Of course, judicial bodies' conferences play a very significant role in this process. First of all, this is true for conferences for higher judicial bodies, since by their very nature, they are empowered to protect human rights, equally respecting political, personal and social rights.
Поддержание диалога тем более важно, что современный мир в очередной раз сталкивается с угрозой разобщения, проистекающей как из пандемии, установившей новые правила социальной дистанции, так и из более глубоких тенденций.
Preserving dialogue is all the more important, given that modern world time and again faces the threat of separation. This threat is conditioned both by the pandemic that created new rules of social distancing and by more deep tendencies.
Я имею в виду скрытое подчас за глобализацией стремление необдуманного переноса и применения стандартов, ценностей одного государства или группы государств на весь мир.
I mean the intention, sometimes concealed by globalization, to automatically impose and imply the standards and values of one state or group of states to the whole world.
Думаю, уместно напомнить слова известного немецкого философа Юргена Хабермаса, который в книге «Расколотый Запад» утверждает, что хотя либеральная версия конституционализма позиционируется как универсальная, как нейтральная и объективная, она практически используется как фактор геополитики, фактически давление западного дискурса, обеспечение его доминирования над параллельными дискурсами.
It seems appropriate here to make reference to Jürgen Habermas, who in his work Divided West states that while the liberal version of constitutionalism is perceived as universal, neutral and objective, it is in fact utilized geopolitically, in fact, like mean of pressure of the Western discourse, ensuring its dominance over parallel discourses.
Описанный философом подход граничит с разрушением права.
The described by the philosopher's approach is close to the disintegration of law.
Он может угрожать сердцу каждой нации, выраженного в ее праве на существование, то есть в сущности тому, что мы называем конституционной идентичностью.
It can threaten the heart of every nation. I mean the basics of their existence represented in their law, in essence, something that is sometimes called constitutional identity.
Международное сообщество осознает опасность агрессивной универсальности.
The international community understands the danger of aggressive universality.
Достаточно напомнить о предельно объективной и нейтральной Азиатской декларации прав человека 2012 года, положение которой подчеркивает, что права человека должны применяться с учетом регионального национального контекста, то есть в сущности с учетом конституционной идентичности.
Suffice to remind of the perfectly objective and neutral ASEAN Human Rights Declaration of 2012. Its provisions underline that realization of human rights must be considered in the regional and national contexts, which practically amount to constitutional identity.
Я бы в своем выступлении хотел сказать несколько слов о российском опыте судебной аргументации национальной конституционной идентичности, в особенности в контексте наших отношений с Европейским судом по правам человека.
I would like to say a few words about the Russian judicial experience on protection of national constitutional identity, particularly in the context of relations with the European Court of Human Rights.
Надо признаться, что в этом контексте конституционная идентичность иногда характеризуется как оборонительная концепция, используемая при столкновении нашей страны, которой, кстати, 20 миллионов мусульман, со своего рода принудительным продвижением универсалистской версии конституционализма.
I must confess, in this context, constitutional identity sometimes is described as defensive concept, used when our state where 20 million Muslims lives, by the way, is confronted with somewhat coercive promotion of universalist version of constitutionalism.
Дело, о котором я сейчас буду говорить, известно российским и, вероятно, европейским конституционалистам.
The situation which I will cite further is well known for Russian and likely European constitutional scholars.
Для представителей государств, не входящих в Совет Европы, однако она может представлять определенный интерес как иллюстрация работы органа конституционного контроля по защите конституционных норм, входящих в ядро национального конституционного порядка.
But for the states outside the Council of Europe, it may be of interest as an illustration of the work of constitutional supervisory body on protection of constitutional norms, included in the essence of national constitutional legal order.
Это пример трудного поиска компромиссов.
This is an example of a hard way to search for compromise.
Постановление 2013 года по делу Анчугов и Гладков против России Европейский суд по правам человека подверг критике норму статьи 32 Российской Конституции.
In its judgments of 2013 in the case Anchugov and Gladkov versus Russia, the European Court of Human Rights criticized Article 32 of the Russian Constitution.
Эта статья находится в главе Конституции, которая не может быть изменена парламентом.
This article is located in Chapter 2 of the Constitution, and it cannot be changed by the Parliament.
Для такого изменения необходимо создавать конституционное собрание, которое либо подтвердит неизменность Конституции, либо разработает новый проект Конституции.
Such changes require establishment of a constitutional assembly, which either confirms the invariability of the constitution of the Russian Federation or drafts a new constitution subject to adoption by a nationwide vote.
В статье 32 Конституции, которую Европейский суд признал несовместимой с Европейской конвенцией прав человека, установлено, что не имеют права избирать и быть избранными граждане, содержащиеся в местах лишения свободы по приговору суда.
The Article 32 of the Constitution, criticized by the European courts, fully forbids participating in votes for a person convicted by court to prison terms.
Как же Россия отреагировала на это решение Европейского суда?
So what was the reaction of the Russian Federation to this decision of the European court?
В 2015 году полномочия Конституционного суда России были дополнены нормой, которая предусмотрела возможность по запросу компетентных государственных органов оценивать исполнимость решения Европейского суда в России.
In 2015, the powers of the Constitutional Court of the Russian Federation were expanded. The new norm of law empowered the court to check the possibility of execution of international court judgments under the Constitution of the Russian Federation upon request of competent state authorities.
Первым решением Европейского суда, в исполнимости которого усомнились государственные органы Российской Федерации, стало постановление по делу Анчугов и Гладков.
The first judgment, the execution of which was deemed doubtful by the state authorities, became the Anchugov judgment.
В 2016 году Конституционный суд Российской Федерации принял постановление, в котором указал, что взаимодействие Европейского конвенционного и российского конституционного правопорядков невозможны в условиях субординации.
In 2016, the Constitutional Court adopted the judgment in which it made a reminder that interaction of European Convention order and Russian constitutional order is not conducted subordinately.
Необходим только диалог между различными правовыми системами, и он является основой их надлежащего равновесия.
Only a dialogue of different legal systems shall be the basis for their adequate balance.
А значит, от уважения Европейским судом по правам человека национальной конституционной идентичности во многом зависит и уважение Европейской конвенции по правам человека.
Therefore, the respect for European Convention of Human Rights largely depends on the respect shown by the European Court of Human Rights to national constitutional identity.
Конституционный суд признал невозможным исполнение постановления по делу Анчугов и Гладков против России в части внесения изменений в главу 2 Конституции.
The Constitutional Court held that it was impossible to execute the Anchugov and Gladkov versus Russia judgment by amending Chapter 2 of the Constitution.
Но одновременно он указал, что является возможным и реализуемым в российском законодательстве и судебной практике исполнение этого постановления в части мер общего характера, обеспечивающих справедливость, соразмерность и дифференциацию применения ограничений избирательных прав.
But at the same time, it was deemed possible to perform in the legislation and case law such execution of this judgment that pertains to general measures ensuring fairness, proportionality and differentiation of limitation of electoral rights.
Другими словами, суды при назначении наказания в виде лишения свободы должны принимать во внимание последствия в виде ограничения избирательных прав.
In other words, the court imposing prison terms should take into account the fact of deprivation of electoral rights.
Кроме того, федеральному законодателю была дана рекомендация оптимизировать систему уголовных наказаний, в том числе посредством перевода отдельных режимов отбывания лишения свободы в альтернативные виды наказаний, хотя и связанные с принудительным ограничением свободы осужденных, но не влекущие ограничения их избирательных прав.
It was also recommended to the federal legislature to optimize the system of criminal punishments, including by way of transferring certain regimes of serving the sentence in the form of deprivation of liberty into separate types of punishment, connected to limitation of freedom, but not limiting electoral rights.
И эта рекомендация была выполнена парламентом. Вместо лишения свободы, предполагающего ограничение избирательного права, в ряде случаев в настоящее время за совершение отдельных преступлений применяется назначение принудительных работ, не ограничивающих избирательные права.
This recommendation was fulfilled. In some cases, deprivation of liberty implying limitation of electoral rights now can be changed to compulsory labor that does not limit electoral rights.
Компромисс таким образом был найден. Указанный комплекс мер в 2019 году был признан Комитетом министров Совета Европы надлежащим способом исполнения постановления Европейского суда.
The compromise has thus been found. The described set of measures was in 2019 recognized by the Committee of Ministers of the Council of Europe, which accepted that it was an adequate way to execute the Anchugov judgment.
Более того, опыт России использовала Великобритания, которая в течение длительного времени искала способ исполнить аналогичное по сути постановление Европейского суда по делу Хёрст против Соединенного Королевства.
Moreover, the United Kingdom has turned to the Russian experience when it conducted its lengthy search for the way to execute the very similar judgment of the European Court of Human Rights rendered in 2005 in the case of Hurst versus the United Kingdom No. 2.
Таким образом, судьи Конституционного суда России показали, что далеко не каждый случай конфликта между нормами национального, международного права и нормами Российской Федерации надо воспринимать как покушение на российскую конституционную идентичность.
Thereby, the judges of the Constitutional Court of Russia demonstrated that not every conflict between norms of national legislation, international law and the Constitution should be perceived as a tax on the Russian constitutional identity.
В защите нуждаются особо защищенные от текущего пересмотра части Конституции, составляющей ядро национально-конституционного порядка.
Defense is required for part of constitution specially protected from review, the embodiment of the essence of the national constitutional order.
Далеко не все, относящиеся к области права традиций, входят в это ядро.
Not all legal traditions are included into this essence.
А потому необходима методология различения тех правовых ценностей, разрушение которых угрожает конституционной идентичности, и таких ложных, по сути, ценностей, которые основаны на предрассудках, просто стереотипах общественного сознания.
Therefore, a methodology is required to distinguish between legal values that cannot be challenged without threatening constitutional identity, and such values that are in nature flawed, based on superstitions or social stereotypes.
Надо в этом широком спектре видеть, что есть и конституционная идентичность, но может быть и инерционность, граничащая с анахронизмом.
In this broad spectrum, it must be understood that there is constitutional identity, but there is also inertia, close to anachronism.
Мир многообразен, и поиск точек соприкосновения и основы для диалога не должен означать полной потери культурной идентичности.
The world is very diverse, and search for common points and basis for dialogue must not transform into full loss of cultural identity.
Напротив, этот поиск должен стать основой для глубокого взаимопонимания и взаимоуважения.
On the contrary, this search must become basis for deep mutual understanding and respect.
Именно общие ценности разных народов могут обеспечить сотрудничество и процветание.
The common values of different nations can ensure cooperation and flourishing.
Помощь и диалог, а не принуждение и противостояние должны сопутствовать миру.
Help and dialogue must accompany the world and not coercion and conflict.
Не случайно тема «Мир и конституционное правосудие» является темой предстоящего в следующем году Конгресса Всемирной конференции конституционного правосудия.
It is no coincidence that the theme Constitutional Justice and the Peace is chosen for the Congress of the World Conference of Constitutional Justice coming next year.
Таким образом, темы обсуждений, заявленные на настоящем мероприятии, приобретают особую актуальность.
This also confirms that the discussion at the present event acquires special urgency.
Роль судебной власти в поддержке гуманизма и демократии, а также защита прав в плюралистическом обществе подчеркивают прогресс в понимании и применении правовых ценностей.
The role of judiciary to promote humanity and democracy and the protection of rights in pluralistic society underline progress in understanding and application of legal values.
Но также и указывают на перспективы развития судебных систем наших государств.
But these themes also point to perspective of development of the judicial systems of our states.
Важно, что происходит диалог единомышленников, задача которых не доказать превосходство, а поделиться опытом и найти пути решения общих проблем и задач.
Importantly, we have a dialogue of kindred souls who do not see their mission as proving superiority, but instead strive to exchange experience and find solutions for common problems and quests.
Это показали прошедшие вчера и сегодня обстоятельные и очень интересные дискуссии.
This was proven by fruitful and insightful discussions that took place yesterday and will be continued today.
Для меня лично большое удовольствие участвовать в настоящем мероприятии.
I have a great pleasure to participate in the present event personally.
Dites-vous que les gendarmes et les enfants sont vaccinés contre la méningite?
Я хотел бы вновь поблагодарить господина Анвара Усмана.
In conclusion, I would like once again to express gratitude to Constitutional Court of Indonesia and its President, His Excellency Anwar Usman. Thank you for your attention.
Thank you very much, Justice Gedis Gadziev from Constitutional Court of the Russian Federation. Your presentation was raising the importance of finding common ground without losing an identity. The world is very diverse, and everyone would like to live in harmony, so mutual respect and cooperation are truly fundamental. Thank you for your kindness. Now, for the next speaker, we will have the Chief Justice of the Supreme Court of Bangladesh, His Excellency Said Mahmood Hossain. For the Chief Justice Hossain, the floor is yours. Mr. Hussein, maybe you are left unmute. Mr. Hussein, can you hear me? Please check your mic.
Yes.
Okay, thank you.
Thank you.
Please.
Honorable Chairman of this session, Mr. Justice Manahan Sitompul, the Honorable Judge of the Constitutional Court of Indonesia, my dear fellow panelists, esteemed brother and sister judges of different countries, distinguished representative of international organization, distinguished participant, ladies and gentlemen, Assalamu alaikum and a very good afternoon. It is indeed a great pleasure to be here in the midst of legal luminaries and distinguished scholars of different countries around the globe. At the very outset, I would like to express my humble gratitude to the Honorable Chief Justice of the Constitutional Court of the Republic of Indonesia, Mr. Justice Anwar Usman, for inviting me to attend this very significant and timely conference on human rights and constitutionalism, the contribution of judiciary in Muslim countries. I am overwhelmed with the utmost pleasure to be part of it. I prefer to speak on the role of judiciary in promoting humanity and democracy. The most significant value of human life is best reflected in recognizing human rights and exercising these rights to the extent that it preserves humanity. Life would be meaningless if individuals could not practice their natural right or adapt their political opinion they believed. Moreover, life would be unendurable if the individuals are unable to enjoy this security in their respective communities. Conceptually, democracy placed within a liberal symbolic framework draws together the process of representation and election with the imposition of law and rights, the human rights and the idea that the people are bound by the rule that originate from their participation in lawmaking process by means of electing representatives from their constituencies. Democracy is one of the fundamental principles of Bangladesh embodied in the preamble of the Constitution. The judiciary is obliged to protect the rights and liberties of the citizen through judicial review and judicial activism. Courts often travel beyond the normal roles of being more adjudicators by setting out principles and guidelines that the executive must carry out. The term judicial activism can be traced back to Marbury versus Madison case, where Chief Justice Marshall of the USA observed it is for the court to say what the law is. Thus, he laid down the foundation of judicial review and judicial activism. Article 8 of the Universal Declaration of Human Rights enumerates that everyone has the right to an effective remedy by the competent national tribunals for acts violating fundamental rights granted to him by the constitutional law. In Bangladesh, the constitution has not only guaranteed fundamental rights and the scope of their judicial enforcement, but also sufficiently empowered the High Court Division of the Supreme Court of Bangladesh to apply them through appropriate directions or order to any person or authorities, including public functionaries. Article 44, Sub-Article 1 of the Constitution of Bangladesh guarantees that the right to move before the High Court Division of the Supreme Court is to enforce the fundamental rights of every citizen. The Constitution of Bangladesh incorporates 18 fundamental rights under Part 3 that are enforceable by orders of the court. The High Court Division of Supreme Court of Bangladesh has also been given the power to issue appropriate writs to remedy any legal wrong or enforce any legal obligation. The concept of public interest litigation has been developed by the Supreme Court of Bangladesh over the years to provide adequate legal remedies to the poor, socially vulnerable, backward, and minority groups who have faced with limited access to the courts or failed to get judicial remedies due to lack of legal knowledge and consciousness. The Supreme Court of Bangladesh has begun its journey in 1972 by formally acknowledging its sublime responsibility to help build an equitable social order through rule of law. On this auspicious occasion, I feel the urge to focus on instances which the Supreme Court of Bangladesh courageously played a significant role in promoting democracy. A quintessential episode to flourish democracy can be discernible in 1992 in Kudruti Ilahi Ponir versus Bangladesh case, where the appellate division of the Supreme Court of Bangladesh, as a promoter of democracy, exercised strategic activism by issuing series of structural injunctions, but refusing to strike down the act of the parliament. The petitioner, a political figure, challenged the act that repealed the existing local government tier, namely Upazila, on the ground that abolishing of local government institution would be incompatible with Article 59 and 60 of the Constitution that provided for elected local government bodies. In this groundbreaking decision, the appellate division acknowledged that the legislature's authority in the field, but nonetheless issued certain direction asking the government to make all existing local government laws compatible with constitutional framework relating to local governance and public participation. A constitutional amendment was nullified by the Supreme Court in 2005 in the case of Bangladesh Italian Marble Works Limited versus Bangladesh, famously known as Fifth Amendment case. While the Fifth Amendment of the Constitution was made to protect the first martial law regime, the court observed that martial law does not have any authority to bring about amendment to the Constitution. Similarly, the Seventh Amendment to the Constitution, which attempted to legitimize the second martial law regime, was also declared unconstitutional by the High Court Division in Siddiq Ahmed versus Bangladesh case in 2011. The Supreme Court of Bangladesh not only contributes to establish democracy and rule of law, but also ensures public and private individual or organization to abstain from misuse of power with a view to safeguarding and protecting individual rights and liberties. I would like to portray a glimpse of the Supreme Court roles in protecting humanity through court's order. In 2003, in the case of Bangladesh Legal Aid Services Trust versus Bangladesh, the Supreme Court in a pioneering decision ensured that persons suspected of crimes are not subjected to torture, arbitrary arrest, or summary execution by the police. They must be treated under due process of law. In 2009, Human Rights and Peace for Bangladesh versus Bangladesh case, an instance of judicial activism by the Supreme Court, paved the way for the government to improve the condition of polluted rivers. In the same year, in Bangladesh National Women's Lawyers Association versus Bangladesh case, the Supreme Court issued guidelines to prevent sexual harassment against women till proper legislation comes into effect. In a landmark judgment concerning women's rights in the case of Bangladesh Legal Aid Services Trust and others versus Bangladesh in 2009, the High Court Division declared that imposition and execution of extrajudicial penalties, including those in the name of execution of fatwa, by traditional dispute resolution process have no sanction in the eye of law. In this case, the court cited the constitutional mandate of equality and the state's international human rights treaty of the obligation to ensure women's right to live free from violence. The court further directed that law enforcing apparatus and local government agencies to take preventive measures from issuing such fatwas in their respective areas and to take legal steps for prosecution of offenders in appropriate cases. Last but not the least, I would like to mention that the most recent occasion of this year where the appellate division of the Supreme Court of Bangladesh in the case of Ataur Midha versus Bangladesh finally observed the issue of imprisonment for life, defining it equivalent to imprisonment for 30 years with the scope of remission as per law. I hope this compassionate way of interpreting and applying law will serve an outstanding standard in the upcoming days to further constitutionalism in Bangladesh. I would like to recall the words of Francis Bacon. If we do not maintain justice, justice will not maintain us. The judiciary of Bangladesh continues to dispense even-handed justice in all circumstances and upholds democracy and humanity by promoting the rule of law with a strong commitment to the nation. Since its journey, the Supreme Court of Bangladesh has been performing as the flag bearer of constitutionalism and rule of law. Hopefully, this journey will continue till the doomsday. I think we will be benefited by sharing our thoughts and experiences today, which is indeed the spirit of this conference. May our friendship be long lasting. May Almighty, the Lord of the universe, protect the globe from COVID-19 pandemic. Stay safe. With these few words, I conclude. Thanks for bearing with me.
Thank you very much, Chief Justice Sheikh Mahmood Hussain from the Supreme Court of Bangladesh, for sharing your perspective and best practices. The speech was concluded by the quote, if we don't maintain justice, justice will not maintain us, which is really true, and that we as a judiciary should always guard and protect the democracy and humanity of our nation. I think your speech very important thing to this conference. Thank you.
Thank you.
Yes. Ladies and gentlemen, for the fourth speaker, we will have Her Excellencies Marie-Louise Abomo, Justice of the Supreme Court of Cameroon. Justice Abomo, please, the floor is yours. Mrs. Abomo,
Excellence.
Okay.
Excellence, Monsieur le Président de la Cour constitutionnelle de la République d'Indonésie,
The President, the Chief Justice of Indonesian Constitutional Court, Chief Justices and Presidents of different other constitutional courts. It is an honor and a joy for me to be able to join you in this conference to share our experience in this conference. My name is Marie-Louise Abomo from Cameroon. In this opportunity, I would like to quote Daniel Comasone. I would like to extend his apology for he is not able to be here, and I am here to represent him. I would like to share the experience of Cameroon related to the theme of our conference today. Is about the pluralist society, protection of social, economic, and cultural rights. We know that in different countries, we have Department of Justice, we have judiciary institutions that are intended to protect the society, protect individuals. Department of Justice here and judiciaries in the context of pluralist society
ethnies au moins, et sa triple culture juridique.
is indeed Cameroon, a very pluralist society. We have more than 200 ethnicities with various historical background and social background. So that's to give you some idea about how plural is and how diverse is the society in Cameroon.
La vie familiale, la participation.
And today we will also talk about rights, social rights, and also social protection rights.
Il s'agit, comme l'a dit un auteur, d'un ensemble de valeurs.
This has to do with the right to food, to water. There are so many values contained here in terms of positive protection that we can see within the Cameroon Constitution. Many different points addressed here. In terms of protection, the Constitution does contain provisions on protection that falls under the executive powers. There are also other institutions that have been set up, such as the National Commission for the Promotion of Bilingualism and Multiculturalism. The Cameroon Society and its constitution here gives the same right, the equal rights for its citizens. The state of the government guarantees the rights of the citizens according to the Constitution. The Constitution also, there are certain freedoms or liberties, such as in terms of religion, and we also, of course, protect the rights such as religious freedom and other things. Cameroon is a secular state and a country that has decentralization because there is the principle of equality. Cameroon also has two national languages, French and English. There is something that we adhere to, which is bilingualism. There's the Article 62 that states that there is protection on the rights and the application of the system of decentralization. This has to do with legal organizations, the establishments of cultural institutions. These are all that would protect the rights of citizens. There's article in the Constitution whereby we can see the status and the function of regulators that regulates, and there are various agreements or international treaties. And Article 50 states that the decisions of the Constitutional Council it is binding on authorities and binding to legal persons. This decision cannot be appealed. This is according to our Constitution. There's also, in 2018, the Constitutional Council also saw, and in view of many things, including the decentralized model, which means that there is a pluralism for the protection of various social aspects. There's a decision that organizes this decentralization in the regions in 2019, which is the General Code of Decentralized Territorial Collectivities. This law views particularism or the particularity, and in Article 5 speaks about two things, which is the sociological component of the decision-making bodies in those collectives. There's also other provisions on these decentralizations. The Cameroon country also has thought of the judicial organization and the fact that it needs to view multiculturalism or pluralism. There are two principles that are abided here. The first is the option of jurisdiction prevails legislative option, because Cameroon sees that there are traditional or customary jurisdiction. We also have because in our history there's an inheritance from British or Anglo-Saxon aspects, but also there are traditional laws as well. So there are two aspects here. Administratively, in the regions, the judiciary uses also the system that is based on the common law system, and this sees or the Supreme Court is placed in the middle in terms of the application of the law, in terms of the promotion of rights and democracy. The structure in this case, if we choose or make choices, we have to see that the jurisdiction of the law based on these divisions and from an administrative point of view, there are 5 things that can address various issues. There's the penal or civil, there's a sociological composition, and there's civil, criminal, social, commercial, and common law. So this is because of the plural nature of Cameroonian society. Because of the multiplicity of customs and cultures. And that is why customary rights or local rights is something that is viewed by the Supreme Court, because judges can issue decrees that has to do with tradition or customs. And the Supreme Court recognizes customs as important for the Cameroonian nation. This is not something that can be separated from the task of the judiciary. Cameroon, because historically also follows the British system, then if we make decisions in the southwest and the northwest, in some areas, the law that is applied there is the common law system. And that is why this applies to both sides of the society, which is English speaking and French speaking. Again, because we adhere to the principle of bilingualism. If we are speaking English, then there would be French interpreters. Again, we recognize that as part of diversity, of pluralism. Then we have to set up certain facilities, such as interpreters. We make sure that the circumstances continue to protect individual rights, the rights of citizens. For example, for administrative cases, there is an acknowledgement or recognition of the person's language. There's also a promotion of that bilingualism, both English and French. We also have consultative institutions that also has to give an account to the President of the Republic to see what happens in the field. For example, to engage in discussions and make sure that the discussions can be done both in English and in French. Bilingualism applies down to the local level and at the national central level. so both at the lower level for the promotion of bilingualism and multiculturalism. It has 15 members, and the members come from national level figures, intellectuals, and other leaders, and they hold a mandate of 5 years. They also have to be accountable to the president. Mr. Chief Justice of the Constitutional Court of the Republic of Indonesia, ladies and gentlemen, I have provided to you a short description of the role of the judiciary in Cameroon that has to do with the theme today, because protection and promotion needs to be continued, but there are many progressive things that needs to be done by the government. Thank you.
Thank you very much, Justice Maria Louise Abomo from the Supreme Court of Cameroon. I note a short conclusion from your speech, such as below. The reality is that the world that we live in is full of diversity. So, responding positively to the diversity by showing mutual respect will be the key to a harmony for the people. The protection of the fundamental rights of everyone is a work that has been done, but also at the same time, a work that is still in progress. Thank you, Madam. Ladies and gentlemen, respected delegates, now we have arrived at the final presentation, which will be delivered by His Excellency Muhammad El-Haj Kachem, President of the Supreme Constitutional Court of Palestine. Mr. President, please, the floor is yours.
بسم الله الرحمن الرحيم والصلاة والسلام على سيدنا محمد وعلى آله.
In the name of God, the most merciful, the most compassionate, praises and greetings to the Prophet Muhammad, his family, and his companion and his followers till the end of time. His Excellency, the President of the Constitutional Court of Indonesia, Mr. Anwar Usman, Their Excellencies, Head of Constitutional Court, Supreme Courts, and Constitutional Councils who attend this conference. Ladies and gentlemen, first of all, I would like to thank the President or the Chief Justice of the Indonesian Constitutional Court of the Republic of Indonesia for inviting me to this conference. I am very pleased for the convention of the Second Judicial Conference of the OIC. And I'm also very happy to have the opportunity to discuss about the Constitutional Court of Palestine's role in protection of human rights and freedoms, and also to reaffirm the commitment of Palestine to protect human rights and fundamental freedoms stipulated in our constitution, and also to emphasize on the role of the Constitutional Court of Palestine to respect and protect rights and freedoms of the Palestinian citizen. With its clear impact on achieving the right state and consolidating the rule of law and democracy. It can be said there is no democracy without a constitutional exclusion that guarantees the application of provisions in the constitutions in a comprehensive manner by determining the rule of the states and the rule of law. The existence of the rule of law can only be established in the existence of an effective and independent judiciary. Constitutional oversight is one of the means of oversight over legitimacy to support the human rights and freedom. The Constitutional Court of Palestine plays important role to guarantee the rights and freedom as stipulated in our constitution, which is the temporary law of Palestine. And for us, this is actually the basic formula to provide the freedom and human rights for all Palestinian people. The Palestinian Constitution, which is the temporary Constitution 2003, has made it possible for us to ensure the cohesiveness of the Palestinian people with the unity of intention, with no discrimination and equal status for all the Palestinians. Islam is the official religion in the Palestine, and other Abrahamic religions are being respected. The Constitutional Court of Palestine also ensure that all other government and state agencies can really implement and exercise their duty. The Constitutional of Palestine also ensure personal rights and freedom of economics and civil and cultural freedoms. The most important work of the Constitutional Court of Palestine is to cement the value of humanity and the principle of rule of law, as well as protecting human rights and freedoms as follows. First of all, we consolidate the principle of criminal sanction or criminal code based on the existing regulations. So we believe that everyone has their own noble value. Every person has noble or supreme value, so no one should be subjected to unfair punishment that he or she does not deserve. This is or complicate its proportionality with the crime he committed. It is very important for us to ensure that there is no arbitrary action against individuals, and we also want to make sure that there is no arbitrary arrest and detention, as well as arbitrary restriction of freedom of movement. So we want to ensure individual freedom as it is actually part of the collective freedom. The Palestinian Constitutional Court also would like to reaffirm that basically we respect a presumption of innocence principle even for the suspect and defendants until there is a conviction from the court. This principle of presumption of innocence extends to every individual. So basically, if an individual commit a crime, then he will be convicted for his crime. But if that individual is not committing or did not commit the crime accused to him, then he should not be convicted. Second, ensuring stability and peace in the social life. Any distortion of right of the state from the state is an issue between individual. So the issue of constitutional justice and what is on the shoulder of the Constitutional Court is actually a mandate to maintain stability and ensure that there is no injustice in social life and forums, as it is the first duty of the Constitutional Court. And this is also in line with the ruling of the of the Constitutional Court of Palestine. So basically, we do not want to burden all the litigants, especially we want to ensure equality before the law. This principle is actually equal to civil and individual liberty. Individual liberty is a sacred principle, which is part of the Palestinian constitution, because we believe that it is a basic pillar for rights and freedoms of all kinds based on public justice. So basically, we want to ensure that we do not discriminate based on race or based on ethnicities. We want to provide equal protection for all Palestinians. If the decision of court is not in line or with the Constitution, then we will review the case. But the most important thing here is we want to make sure that all litigants are equal before the law, and they will also have the right to appeal if they are not satisfied with the decision of the lower instance court. And but at the same time, we also want to make sure that we have independent judiciary institution, so every individuals can feel can feel or can trust that their case and their rights can be protected in the court, as this is actually basic human rights that cannot be waived. This is non-derogable human rights, and parts of the protection of social, economic, social, and cultural rights in Palestine. The Constitutional Court of Palestine also took different interpretative decisions regarding state treaties and agreement. For different treaties and agreements, including for international law for the protection of human rights and freedoms as stipulated in international treaties. The Constitutional Court here will only review international law, treaties, and agreement only for the protection of human rights and freedoms as stipulated in the international treaties. And the Constitutional Court will review whether or not it is necessary to be accessed into the convention. In the context of this decision, the Constitutional Court established interpretation that led to the development of new law in line with the Palestinian Constitution, where the court specified in its explanatory decision who is entitled to sign or ratify the treaties. Your Excellency, the Chief Justice of Indonesian Constitutional Courts, the Chief of Constitutional Courts and Supreme Courts and Councils of the OIC member site. The oversight of the Supreme and Constitutional Court of Palestine is not only providing approval over the issuance of law and regulations, in this case post-application, and the Constitutional Court of Palestine does not monitor the laws issued by the Legislative Council of Parliament, nor the decisions of law issued by the President of Palestine. The laws issued before 1967, before the occupation of Israel, is also not being reviewed. And also back in 1967, we have the Jordanian laws and Egyptian laws were applied in Gaza and West Bank before 1967. Finally, I can say that with humility that although the Constitutional Court of Palestine is newly established less than 5 years ago, despite material, structural, and financial obstacles that we face, despite multiplicity of laws and regulations, despite the absence of conscious constitutional culture and lack of human resources, the Constitutional Court of Palestine able to make great progress in protecting Palestinian human rights and freedoms for the sake of democracy and freedoms of the Palestinian people, including their economic, social, and cultural rights, despite the many obstacles presented by the Israeli occupation and the Israeli arbitrary measures against Palestinian citizens and against the rights and freedoms of Palestinian people, especially in Al-Quds or Jerusalem as the capital of Palestine. We can still manage to protect the rights of the Palestinian people. I wish every success to this conference. Thank you.
Thank you very much, President Muhammad Al-Haj Qasim from the Supreme Constitutional Court of Palestine. I conclude your speech shortly. The personality of an individual, or in this case, a society, should be preserved, and each person has the right to do so. That being said, protection of human rights, it's not only concerning freedom. It is much more than that. And everyone individually or collectively shall be respected for preserving their identity. It was a very clear and insightful presentation, especially on the work of the Supreme Constitutional Court of Palestine and the challenges faced. May the court continue to carry out its responsibility to the people successfully in the future. Thank you for your effort. Now, I give the floor if there is a question from other delegates. Please. Any question from Algeria delegate? Please. Please check your instrument, Mr. Delegate. Is still unmute.
هل تسمعوني؟
Can you hear me? Yes.
شكرا.
Thank you very much. First of all, I would like to explain several points. First, the subject of our conference is human rights. And how can we protect human rights and liberties? It's the subject in this case is the judge. Therefore, the constitution must be based by the judge, and the judge should be independent, and the judge should be protected. Now, if the judge is not protected, how on earth will he be able to perform his duties and function? And in Algeria, our condition is stable, and it's the judicial system is very independent. And even the Ministry of Law is also very separate. And in our case, we can hold the judge accountable to the rule of law. Therefore, I need to affirm that the judge should be independent in order to be able to follow up with all his duties, and that we need to put penalties for the parties that will not implement the constitution, in our laws, there are certain penalties for those who do not implement what has been stated in the Constitution, and that is very important because in case any of the constitutional laws or any laws that has been stated by the court and has not been implemented or has been hindered in its implementation should have a certain punishment or penalty. Thank you.
For Algeria delegation, but I think it's not question, but it's a statement from the Algeria delegation. And then, because any answer did not come to our to this discussion, and then not not answer, and then we continue to the next. Ladies and gentlemen, respected delegates, now we have arrived at the end of the session. I hope this conference successfully enriches us with knowledge and experience across the world. Thank you for staying with us from day one. I wish nothing but success for all of us, and especially this J-OIC Conference in the future. May God bless us with health and safety. Thank you.
Thank you very much, Your Honor, Chairman Session 4, His Excellency Manahan MP Sitompul, for walking us through such a wonderful and eye-opening deliberation during Session 4. And we also express our deepest gratitudes to all of the esteemed speakers taking part in this particular sessions from Pakistan, Russia, Bangladesh, Cameroon, and Palestine. Thank you very much indeed for all of your insights. And we also thank all of our OIC members for submitting your responses and feedback on the draft of Bandung Declaration. Ladies and gentlemen, we will now take a short break. We shall reconvene with the plenary meeting and discussion on Bandung Declaration in 10 minutes. To our online and virtual participants, please stay with us.
Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Bamora, tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya.
apa yang sudah kamu mulai untuk membuat sebuah perubahan. Apa saja aksimu untuk bangsa ini? Karena sejatinya, kita harus membangun negeri dengan bekerja keras. Kami kawal langkah masa depan. Inilah kami. Berawal dari konstitusi, dari MK, siap melayani Indonesia.
Excellencies, Your Honors, ladies and gentlemen, the Judicial Conference on Constitutional and Supreme Court's Councils of the OIC Member Observer States, J-OIC. We have now come to the plenary meeting and discussion on Bandung Declaration with all participants of the conference. The plenary meeting will be chaired by the President of the Constitutional Court of Turkey. Ladies and gentlemen, His Excellency Zühtü Arslan.
Distinguished participants, ladies and gentlemen, we are now closing to the conference, 3 days conference on the constitutionalism and human rights. I would say it's a great pleasure for me to chair this plenary session in which we will discuss the text of draft Bandung Declaration. As you know, the text of the declaration was circulated to you through emails yesterday, and we have received some responses already. But before going through the content of Bandung Declaration and the nature of these responses, I would like to briefly mention about the predecessor, namely Istanbul Declaration. As we all know, the first conference of the J-OIC was held in Istanbul in 2018, and we accepted and issued Istanbul Declaration as a concrete result of that conference. Having emphasized the significant role of our respective courts and councils in protecting and promoting the rule of law and human rights, Istanbul Declaration reiterated the commitments to the idea that a forum must be created among the courts and councils of the OIC member states. To this end, we all agreed to form and mandate a working committee consisting of Turkey, Indonesia, Algeria, Pakistan, and Gambia. I am very pleased to say that the working committee convened 2 days ago here in Bandung and took some advisory decisions concerning the name of the organization and future schedules of its meetings. I am also pleased to see that Bandung Declaration repeats the basic commitments and objectives of Istanbul Declaration and brings us closer to the establishment of an organization among the courts and councils of the OIC members. Ladies and gentlemen, after these introductory remarks, now we can elaborate on the draft text of Bandung Declaration. We will first read the text of declaration and ask all participants whether there is any input or suggestion. As Anwar Usman, the Chief Justice of the Constitutional Court of Indonesia, told us yesterday, the final draft of the declaration was already sent to your emails. Actually, as I said before, we have received so far 4 responses from the member states. Now, would you please read out the draft Bandung Declaration?
The Second Conference of the Constitutional and Supreme Courts, Councils, and equivalent institutions of the member states of the Organization of Islamic Cooperation. Bandung Declaration on Human Rights and Constitutionalism. On 15 to 17 September 2021, the Constitutional Court of the Republic of Indonesia hosted in Bandung the Second Conference of the Constitutional and Supreme Courts, Councils, and equivalent institutions of the member states of the Organization of Islamic Cooperation, OIC, with the theme of human rights and constitutionalism, the contribution of judiciary of Muslim countries. The heads and representatives from 38 constitutional and Supreme Courts, councils, and equivalent institutions of the OIC member observer states, guest courts, and international institutions participated in the conference. The conference presented an opportunity to engage and share knowledge, experiences, and best practices relating to constitutional cases for the promotion of human rights, constitutionalism, and democracy, notably the role of judiciary to promote humanity and democracy, and the protection of social, economic, and cultural rights, as well as civil and political rights in a pluralistic society. Within the framework of their constitutional competence, the constitutional and Supreme Court's councils play an instrumental role to ensure respect for the implementation of national constitution's principle of rule of law, democracy, and human rights. As guardians of these principles and values, as well as the guardians of the Constitution, we, heads and representatives of the constitutional and Supreme Courts, councils, and equivalent institutions of the member states of OIC, declare our commitment to ensure rule of law and work against the widespread xenophobic and Islamophobic discourse and practice, as well as terrorism which undermine the principle of rule of law, promotion of a dignified life for all humanity, and peaceful coexistence between religions and beliefs. Reaffirming the commitment to build partnerships through sharing of information and best practices on constitutional cases for the promotion of rule of law, democracy, and human rights, we hereby agree: 1. To establish a formal platform for the constitutional jurisdictions in IOC member states as an independent forum to exchange experiences and information on mutual concern relating to dealing with constitutional cases and jurisprudence for the promotion of rule of law, democracy, and human rights. 2. To officially launch the platform under the name of Conference of Constitutional Jurisdictions of OIC Member States, CCJ-OIC. 3. To convene the inaugural Congress of the CCJ-OIC next year to be held in Istanbul, Turkey. 4. To continue the mandate of the Working Committee consisting of Indonesia, Turkey, Algeria, Pakistan, and Gambia to prepare the working papers of the conference to be submitted to the Congress, including but not limited to the statute of the CCJ-OIC, the consideration of the relationship of the CCJ-OIC and its interaction with the Organization of Islamic Cooperation. The heads and representatives of delegations present today hereby express their highest appreciation to the Constitutional Court of the Republic of Indonesia for organizing this conference in an outstanding manner and with excellent hospitality. Bandung, 17 September 2021.
Thank you very much. As I said, we have received 4 messages from different countries, and 2 of them would like to make a comment on the draft text of the Bandung Declaration. So Malaysia and Azerbaijan I would like to raise some points concerning the declaration. So first, I would like to give the floor to the representative of Malaysian Supreme Court. Malaysia. Is the representative of the Malaysian Supreme Court among us? Please go on. Yeah, I can see you. Now the floor is yours. Honorable Tun Tank, can you hear us? Please, go on.
Okay. Learned Chief Justices, distinguished participants, ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. First and foremost, on behalf of the Malaysian judiciary, may I take this opportunity to congratulate the Right Honourable, the Chief Justice of the Constitutional Court of the Republic of Indonesia, Dr. Anwar Osman, and the Secretariat for making this conference a grand success. The Malaysian judiciary is highly confident and assured that this conference will be one of the steps towards strengthening human rights and democracy, as well as strengthening the protection of social, economic, and cultural rights in a pluralistic society. I would also like to express that the Malaysian judiciary is pleased to endorse and accept the Bandung Declaration on Human Rights and Constitutionalism, and is committed to working together towards realizing it and achieving the commitments established in the said declaration. We are also committed to maintain the independence of the judiciary in deciding cases without fear or favor. Thank you.
Thank you very much for your contribution. Well, I understand that you are not proposing a concrete change in the text of the declaration. So I will turn to the representative of Constitutional Court of Azerbaijan, who is going to respond. President Ferhat Abdullayev or any other judge or Rauf. Hello, Rauf.
Yes.
Okay, we hear you. The floor is yours.
Yes, thank you. Thank you, Honorable President Mr. Aslam, dear Chief Justices, judges and colleagues. First of all, on behalf of Mr. Ferhat Abdullayev, Chairman of Constitutional Court of Republic of Azerbaijan, I would like to express our compliments to Constitutional Court of Republic of Indonesia for successful holding of present conference. I am pleased to bring to your attention that the Constitutional Court of Azerbaijan fully supports the text of Bandung Declaration with modification that our court proposed concerning paragraph 4. Our court proposes to start paragraph 4 with the word "we" and to delete the words before it. Meanwhile, we are pleased to express our confidence that the establishment of formal platforms for the constitutional jurisdictions of OIC member states will positively contribute to promotion of cooperation among our constitutional review bodies. We wish all of you peace and success in your activities. Thank you, Mr. President.
Thank you very much. Well, I understand that you want to delete the first sentence of paragraph 4, actually some part of first sentence of paragraph 4, beginning with "as guardians of these principles and values, as well as the guardians of the Constitution," right? Can you see the text? So you want to delete this part? Okay. Actually, it was this expression is in a way connecting these two paragraphs, paragraph 3 and paragraph 4. But if you insist on deleting this expression, for me it's fine. Any objection to deleting this expression? Any objection?
Of this?
Sorry?
Who has suggested?
Azerbaijan is suggesting
As
to
guardian of
delete
these,
this part.
as guardians of these principles and values, judges are obviously guardians of the values of human rights and protection of social, economic, and cultural rights, as well as the guardian of the Constitution. So judges are also the guardians of the Constitution.
Well, they just want to delete this part. I don't know the reason, but perhaps they could give us
Let's
a
hear
reason.
the reason.
Yeah,
Sorry?
let's hear the reason.
Rauf Guliyev, would you please give us a reason for deleting this section of, or this part of the fourth paragraph? Why do you want to delete it? Rauf Guliyev, the floor is yours. Could you hear us? No? Can you hear us? No, we are not on the phone.
No, it's okay. The problem was with the connection. I failed to switch on the balance. The reason of our proposal, Mr. President, is that according to the Constitution of Azerbaijan, Article 8, that it's the head of state who is the direct guardian of the values and the principles that are directly invited in the Constitution. And therefore, in order to preserve this logical connection between this proposal and our Constitution, we decided to propose this kind of modification in this declaration. Thank you, Mr.
Okay. Any objection from the Supreme Court of Pakistan? Chief Justice, any comment? Please, microphone, please.
Actually, the problem is that the Azerbaijan has a separate constitutional system where it provides as a guardian the head of the state of the constitution and principles of values. So that is why they don't.
Well, shall I propose a medium way of compromising?
As guardian of constitution, that much can be said.
Yeah, because
as guardian and protector of the.
Okay, so you want to keep the word guardians?
Yeah.
Can I propose just to delete as well as the guardians of the Constitution? So we can say as guardians of these principles, which refer to the previous paragraph, we, heads and representatives of the Constitutional and Supreme Courts. Would it be okay for the Constitutional Court of Azerbaijan? Well, it is obvious that the constitutional courts or councils are guardians of the principles of rule of law, democracy, and human rights, as well as the guardians of the Constitution. I mean, the Constitution and constitutional values are guarded by the constitutional courts. That is very obvious and very natural. I don't really understand the reason behind the proposal of deleting these expressions. I couldn't quite understand the point you are raising. Mr. Rauf,
Mr. Chair, may I add something?
Please, go on.
You see, the language used in the draft that we had, and we had suggested changes in it, as guardians of the Constitution, rule of law, democracy, and human rights. Now, these are all powers vesting in courts.
Okay.
The executive doesn't have these powers, as far as I know, in most constitutions of the world. Because rule of law is, and human rights is something which is directly related for its enforcement to courts of law.
So what's your proposal?
As guardians of the Constitution,
yes,
rule of law, democracy and human rights.
Okay. But it's the same thing. Yeah.
No.
No, we just changed
There, the language is different.
Okay. Can we see the text, please, again? Okay. So you are saying as guardians of hold on, as guardians of the Constitution,
the rule of law,
and human rights.
Democracy and human rights.
Can you change it? As guardians of Constitution, of the Constitution, or of Constitution? As guardians of the Constitution, rule of law, democracy, and human rights, we, House of Representatives.
Yeah.
Okay, is that okay for you, Rauf Guliev? Is that okay for?
Yes, thank you. The version that you.
No, we couldn't hear you, Rauf. We couldn't hear. I'm sorry. No, we couldn't hear because your voice is echoing. Hold on.
Is it okay?
Yeah, can you a bit close to microphone because we couldn't hear your voice clearly.
Yeah, okay. Is it okay now, Mr. Chairman?
Okay.
Yeah. The version you pronounced just before, Mr. Chairman, was really acceptable for us. It's as guardians of these principles and values. And then so without mentioning constitution law, I mean that we are not against it, but the logical associated connection with the principle envisaged in our constitution is a little bit, causing the question. But it's not really so important and so remarkable. All the members of this conference are going to support this kind of resolution. We are not against. But our final, let's say so, the proposal is to preserve as guardians of this principle and values, we have and represent. That's all. Thank you.
Okay, thank you very much. Well, I will give the floor to the representative of Algeria, Constitutional Council of Algeria. Okay. Can you hear us?
Yes, I can hear you clearly. Thank you. Ladies and gentlemen, in our opinion, that we need to keep the paragraph the way it is. We, as guardians for the rule of law and democracy and human rights, because that those actually expresses our functions. Because if we wrote principles and values could differ from one system to another, from one country to another, or one regime to another. However, democracy and human rights are universal concepts, and democracy does entail the protection of human rights. Therefore, in our opinion, that we keep the paragraph as it is, but omit the values and principles. Thank you.
Okay, thank you very much. So now the paragraph will be as guardians of the Constitution, rule of law, democracy, and human rights. Well, these are already mentioned, as I said, in the previous paragraph. So we are in a way repeating or re-emphasizing the main function of our courts and councils. So I think it is acceptable now as guardians of the Constitution, rule of law, democracy, and human rights. We as representatives of the Constitutional and Supreme Courts. Is that okay for all of the participants? Any objection to this version of the sentence or paragraph? Any objection? No? Okay, it's accepted. Now I would like to ask the participants if there is any other comment or suggestion on the text of Bandung Declaration. Is there any comment or proposal or
Mr. President,
suggestion?
I have a suggestion.
Please
You
go
see,
ahead,
we
Chief
have
Justice of
in-
Supreme
in,
Court of Pakistan.
In paragraph 1 and paragraph 2, I'll read it, to establish a formal platform for the constitutional jurisdictions. Now, you see, the word jurisdiction relates to powers. It doesn't describe the nomenclature of the forum which exercises that jurisdiction. So, to my mind, I feel that this is grammatically not correct. We can either use the word judicatures, which essentially is another word for judiciary, or we can write judiciaries, constitutional judiciaries in OIC member states. Because jurisdiction does not describe the court or describe the organ of the state which exercises jurisdiction. Jurisdiction is related to exercise of powers.
What about the expression of constitutional justice?
Justice?
Yeah, constitutional justice will be better?
Well, constitutional justice, again, justice would be a concept. We have to refer to an institution which administers these powers.
But it is concept, but also an institution. I mean, constitutional. When you talk about constitutional justice, you talk about also the institutions of reviewing the constitutionality of laws. So
Yeah.
it also includes the institutions. But you are proposing constitutional judiciaries.
Constitutional judiciary or
jurisdictions.
constitutional judicature, Judicature, both mean the same thing.
Can you change it, please, Secretariat? And I think the first letters will be not capital, right?
Yeah, that would be small.
Yeah.
Constitutional judicatures.
Not capital C, yes, constitutional judicators, well, judiciaries, perhaps. Judiciaries is
Either it can be used.
Yeah, okay. Okay, we better use judiciaries, constitutional judiciaries in OIC member states.
Fine. I think
Okay.
that's good
Delete
enough.
the previous one. Yeah.
Likewise, in paragraph 2 also, it's the same word. Paragraph 1.
But
Constitutional judiciaries,
Justice
paragraph
Ahsan,
2,
there is
constitutional judiciaries. Last word in the first line of paragraph 2.
But so hold on. Justice Ahsan, 2 days ago, yes, we convened as the working committee of this conference, and we decided on the name of the organization as the Conference of Constitutional Jurisdictions of OIC member states. And as far as I am aware, this word is also used for, I think, African Association for Constitutional Courts or Councils. They also say Conference of Constitutional Jurisdictions of Africa. So what's wrong with that? I didn't really understand. I mean, we can keep the name.
Well, the J
Well,
remains
the first paragraph, the proposal or the suggestion is okay. I mean, we are talking about the general idea or concept of constitutional judiciaries. But when it comes to the name of the institution we are going to create, we already decided as the working committee on the name of the institution, the association. So I think constitutional jurisdictions can also be used in the name of the organization we are creating.
Yes, but Dr. Arslan, the word constitutional jurisdictions does not essentially describe the institution or the platform that we are aiming for. Conference of Constitutional Judiciaries, that is the conference where judiciaries of all Islamic states are getting together and using it as a platform. Constitutional jurisdiction is a power, it is not an institution. So the name, the abbreviation would remain the same, CCJOIC. Instead of jurisdictions, the J would stand for judiciaries.
Well, yeah,
it's not such a big departure.
Well, it may be, but when you use judiciary instead of jurisdiction, you may exclude constitutional councils. I'm not sure, but I am just thinking now, because jurisdiction is much more general word than the judiciary. Which include also, jurisdiction includes the mandate, the mission of Supreme Courts as well as constitutional councils and constitutional courts.
You see,
but when you say constitutional judiciary, it generally, I think, include the constitutional courts.
Yes.
But this association or the conference will also include Supreme Courts and constitutional councils.
You see, that's why the word judiciary, you see, judiciary by whatever name called, it would be the institution which has the jurisdiction to exercise all the powers that we have mentioned above.
Okay.
If we say constitutional jurisdictions, it is grammatically incorrect.
Well, you mean the name of African Conference is incorrect? They've been using this name for years.
We want the conference.
Well, I told you, the name is Conference of Constitutional Jurisdictions of Africa, CCJA. They are very established association, as far as I know, and they use this name.
I don't know on what basis are they using the name.
The delegates of an Indonesian Constitutional Court will take the floor. Perhaps they will propose a solution to this problem.
Baik, terima kasih.
Yes, thank you. Indonesia is in support of the word jurisdictions. We regard that word is much broader, and it encompasses many different institutions holding that jurisdiction. While we use the more specific word of judiciaries, we are afraid that it would only refer to judicial institutions. So according to us, the first draft of constitutional jurisdictions is more appropriate in this case. Thank you, Chairman.
Still can keep the constitutional judiciaries in the first paragraph. I mean, because it is general expression for the constitutional judiciaries in OIC member states. Okay, is that okay? Is it acceptable now?
Actually, difficulty is also there with regard to the using of the word mere constitutional judiciary or a constitutional jurisdiction. Because so far Pakistan is concerned, every court of law, either of a plenary jurisdiction or a civil court or any court, when any question before them comes with regard to fundamental rights, they always take notice of it and decide the matter on that constitutional point. Specifically, constitutional jurisdiction is conferred in Pakistan on the high courts also. But the Supreme Court of Pakistan is the ultimate court, final court. where the matters are finally on matters relating to constitutional disputes are finally decided. So, to establish a formal platform for the constitutional judiciary, there is a need to provide and make a mention that what judiciary we are referring to. Are we referring to the ultimate and final judiciary, or are we referring to the judiciary which also exercises constitutional jurisdiction but is not a final judiciary in any of the country? So, platform for the ultimate constitutional judiciaries or final constitutional judiciaries, highest constitutional judiciaries, that needs to be mentioned. I don't know about Turkey, whether Turkey has any other court, appellate court, after a decision is given by the Constitutional Court of Turkey. Whether is there any such court there in Turkey?
You mean within the concept of constitutional jurisdiction?
Yes.
Well, in Turkey, when you talk about constitutional jurisdiction, you talk about the jurisprudence of constitutional court itself.
Yes. Is there any appellate forum of the
constitutional
court?
No. I mean, Supreme Court or Court of Cassation is not within the concept of constitutional jurisdiction.
Okay, so there is no appellate forum or any higher forum.
No. When you say constitutional jurisdiction, it relates directly to the work of Constitutional Court of Turkey.
So we can say platform for the Supreme Constitutional Judiciaries.
Supreme Constitutional Judiciary?
Yes.
No. Well, I think, Mr. Chief Justice, this is, as far as I understand, the broadest term we can choose, because every other concepts will have some complications. And as I said, this is already used for organizations, for regional organizations. So I think we should keep as it is. Otherwise, as I said, constitutional judiciaries or supreme constitutional judiciaries, something like that, will create some other complications for different countries. I understand the point you are raising, because you are right, jurisdiction is not an institution, it's a concept or conception, but it is still used and it can be used. Well, we can say constitutional jurisdictions in OIC member states. Well, it doesn't make any sense. It doesn't change anything. So when we talk about constitutional jurisdiction of OIC member states, we are talking about the constitutional courts, constitutional councils, supreme courts who are mandated, given the power to review constitutionality of laws, or some of them are given the power to receive constitutional complaints. So constitutional jurisdictions is the right expression we can use in the name of this organization.
I think this aspect of the matter can also be deliberated when this formal statute of the conference is being made by the committee which has already been constituted for making of that statute.
Are you saying that we should remove the number 2 of this declaration?
No.
Well, we can postpone the issue of the name of the organization, so we can decide later on.
There are two things, with your permission. You see, our anxiety is, as the Honorable Chief Justice has pointed out, that constitutional jurisdictions in various constitutions includes high courts as well as Supreme Court. Now here we are dealing only with the Supreme Courts or the highest fora. So, I mean, it can be, we won't have a problem with constitutional jurisdictions, but before constitutional jurisdictions, conference of the highest constitutional jurisdictions, if we can put, that would address that issue, that it would put the entire thing in its true perspective, that the highest forum which is exercising constitutional jurisdiction, it is a conference of those forums.
Well, I couldn't, agree with you, because putting the word highest means that there are inferior constitutional jurisdictions, but this doesn't make any sense in most of the member or observer states of the OIC. So I think it will be not necessary to put highest constitutional jurisdiction. But I would like to hear from other participants. What do you think about the name of the organization? I see Gianni is there. I know he will be talking in the closing session, but he is very experienced in the field of regional and universal conferences or associations of constitutional courts and constitutional councils. We may have received his ideas on the name of conference and also constitutional jurisdiction.
Yes, Chairman, you can go further on.
Sorry?
I think.
Yeah, Gianni, would you make a comment on the name of the conference? Gianni Bucchicchio, can you hear us? Can you? Yeah.
Voila. Yes, I can hear you. Dear Zutu, concerning the name of your conference, I would like to stick to the name which is in the Bandung Declaration, the jurisdiction, constitutional jurisdiction. If this represents a problem for some courts, perhaps you could quote all the institutions, and in saying conference of constitutional courts, Supreme Court and councils of. So in this way, everybody should be happy.
You are suggesting that instead of the word jurisdictions, we should, or we can put constitutional courts, councils, Supreme Courts? That will be a very long name for the organization.
Dear Zutu, my preference goes, as I said, for constitutional jurisdictions. But if there are problems, the other solution will be what we have said now.
Okay. Thank you very much.
Chairman, may I add something? May I add something with your
Please,
permission?
just Sahsan.
I think for the time being, constitutional jurisdictions can be kept. When we draft the statute, we can define. In the definitions, we would say, what does constitutional jurisdictions means? So this can stay as it is.
Yeah, well, that's what I was thinking, actually. We can elaborate on this issue while we are drafting the statute of the conference.
We agree with that.
Okay, thank you. And the name of the association or the name of the organization is, as it is on the paragraph 2 of the Bandung Declaration, it is the Conference of Constitutional Jurisdictions of OIC Member States, CCJ-OIC. Okay, accepted. If there is no other comment or suggestion, I would like to close the session because we will have a closing session as well. I think there is no other comment, no question, no suggestion, no input. Okay, that means we accepted all Bandung Declaration. Thank you very much. Distinguished participants, dear colleagues, ladies and gentlemen, it's a great pleasure for me to announce that Bandung Declaration was unanimously accepted by the plenary. By accepting Bandung Declaration, we have taken one more step in the way of forming the Conference of Constitutional Jurisdictions of the OIC member states, CCJ-OIC. I am sure this historic decision will be appreciated by the judicial circles throughout the world. Please allow me to thank all participants for their contributions, understandings, and cooperations during the conference. I wish you all happy and healthy days. I would like to close this plenary session by thanking once more the Chief Justice, Anwar Usman, justices, and all staff of the Indonesian Constitutional Court for hosting this excellent conference. Terima kasih. Thank you very much. Thank you.
Thank you very much, Chairman of the plenary meeting of the Bandung Declaration, His Excellency Zuhtu Arslan. Ladies and gentlemen, we will now take another short break as we prepare for the closing session of the conference. Stay with us. Excellencies, ladies and gentlemen, welcome to the closing session of the second conference of the Judicial Conference of Constitutional and Supreme Courts Councils of the OIC Member Observer States J-OIC. Commencing the closing session is the pronouncement of Bandung Declaration, which will be delivered by Chief Justice of the Supreme Court of Pakistan. Ladies and gentlemen, please welcome His Excellency Gulzar Ahmed.
Thank you very much. We are now at the final stages of conclusion of this conference. Bandung Declaration has been finalized, and I have been honored to read the declaration. It reads as follows. The second conference of the Constitutional and Supreme Courts, Councils and equivalent institutions of member states of the Organization of Islamic Cooperation. Bandung Declaration on Human Rights and Constitutionalism. On 15-17 September 2021, the Constitutional Court of the Republic of Indonesia hosted in Bandung the second conference of the Constitutional and Supreme Courts, Councils and equivalent institutions of the member states of the Organization of Islamic Cooperation, OIC, with the theme of Human Rights and Constitutionalism, the contribution of judiciary of Muslim countries. The heads and representatives from the 38 constitutional and Supreme Courts, councils and equivalent institutions of the OIC member, observer states, guest courts and international institutions participated in the conference. The conference presented an opportunity to engage and share knowledge, experiences and best practices relating to constitutional cases for the promotion of human rights, constitutionalism, and democracy, notably the role of judiciary to promote humanity and democracy and protection of social, economic, and cultural rights, as well as civil and political rights in a pluralistic society. Within the framework of their constitutional competence, the Constitutional and Supreme Courts councils play an instrumental role to ensure respect for the implementation of national constitutions, principles of rule of law, democracy, and human rights. As guardians of the Constitution, rule of law, democracy, and human rights, we, heads and representatives of the Constitutional and Supreme Courts, councils and equivalent institutions of member states of OIC declare our commitment to ensure rule of law and work against the widespread xenophobic and Islamophobic discourse and practice, as well as terrorism, which undermine the principle of rule of law, promotion of a dignified life for all humanity, and peaceful coexistence between religions and belief. Reaffirming the commitment to build partnerships through sharing of information and best practices on constitutional cases for the promotion of rule of law, democracy, and human rights, we hereby agree. 1. To establish a formal platform for the constitutional judiciaries in OIC member states as an independent forum to exchange experiences and information on mutual concerns relating to dealing with constitutional cases and jurisprudence for the promotion of rule of law, democracy, and human rights. 2. To officially launch the platform under the name of Conference of Constitutional Jurisdiction of OIC Member States, CCJ OIC. To convene the inaugural Congress of CCJ OIC next year to be held in Istanbul, Turkey. to continue the mandate of the working committee consisting of Indonesia, Turkey, Algeria, Pakistan, and Gambia to prepare the working papers of the conference to be submitted to the Congress, including but not limited to 1. The Statute of CCJ-OIC. Next, the consideration of the relationship of CCJ-OIC and its interaction with the Organization of Islamic Cooperation. The heads and representatives of delegation present today hereby express their highest appreciation to the Constitutional Court of Constitutional Court of the Republic of Indonesia for organizing this conference in an outstanding manner and with excellent hospitality. Bandung, 17 September 2021.
All right, ladies and gentlemen, the Bandung Declaration has been agreed upon. The video that you just saw illustrated the origin and core missions of the declaration and how Bandung came to be the prominent and main destination for the declaration to take place. Once again, congratulations. And now, ladies and gentlemen, it is my utmost honor to invite a special remarks from the chairman of the Constitutional Court of Algeria. Please join me in welcoming His Excellency Kamel Fenich.
شكرا سيد الرئيس. بسم الله والحمد لله.
Thank you, Mr. Chair. In the name of God, salutations and praises to the Prophet. Chief Justice of the Indonesian Constitutional Court, congratulations for the successful conference. We are participating in the joy of this success. Conference that is held amidst the coronavirus pandemic. We, Algeria, we fully support the continuous work in cooperation and support the writing of the statute. I also would like to say thanks to all the organizers and participants. Thank you.
Thank you very much indeed, Your Excellency Kamel Fenich. And now, moving on, Excellencies, ladies and gentlemen, it is my honor to invite yet another special remarks from the President of Venice Commission. Joining us all the way from Italy, we welcome His Excellency Gianni Bucchicchio.
The Constitutional Court of Indonesia, presidents of the Constitutional Courts, members of the Conference of Constitutional and Supreme Courts and Councils of the OIC member and observer states, ladies and gentlemen. Thank you very much for having time invited me to make a congratulatory closing statement at your second conference. It is with keen interest that I take note of the intention of the Conference of Constitutional and Supreme Courts and Councils of the OIC member and observer states to establish itself as a stable organization. Your organization will span seven continents. I see that you have participants from Africa, Asia, and Europe. You cover a wide area ranging from Gambia in the west to Indonesia in the east. I warmly welcome that all your participating boards and councils are linked to the Venice Commission either through agreements with regional or language-based groups and or your membership in the World Conference on Constitutional Justice. Therefore, I warmly invite the participating boards, which have not yet done so, to appoint liaison officers with any commission. The liaison officers regularly send us summaries of important decisions to include into our common codices database. They also have access to the restricted benefits forum for direct exchange of information between the courts. Established in 1996, the codices database already contains some 11,000 judgments. It is a showcase of your case law, and it is essential that you present your judgments to the other courts within the region and worldwide in this way. Dear President Usman, I am pleased that next year our host today, the Constitutional Court of Indonesia, will host the 5th Congress of the World Conference on the topic Constitutional Justice and Peace. I would like to thank the Constitutional Court of Indonesia for your generous offer to host the 5th Congress and for the careful and thorough preparation for this event. I would like to warmly invite those courts present here that have not yet done so to join the 117 constitutional courts, councils, and supreme courts of the World Conference as a full member. Let me conclude with congratulating you and all participating courts and councils for having successfully held the second Conference of Constitutional and Supreme Courts and Councils of the OIC member and observer states. The important discussions today have shown that your conference is a viable group and you are able to organize complex, large-scale exchanges in the field of constitutional law. You promote comparative constitution at its best. The Venice Commission and the World Conference stand ready to continue our fruitful cooperation. Thank you very much for your attention.
Thank you very much, Your Excellency Gianni Boccaccio, for the wonderful remarks. Excellencies, ladies and gentlemen, throughout the course of the conference, we have witnessed and learned about practices of constitutionalism as well as fights for human rights from different parts of the world. Bandung, in the meantime, has also been a wonderful home to our conference this year, offering both its history and its beauty. And now let us reminisce all the highlights from the second J-OIC conference. Ladies and gentlemen, please take a look.
we will discuss tomorrow and on Friday the issue of human rights and constitutionalism, with a special reference to the contribution of constitutional courts and Supreme Courts to the ideas of rule of law, constitutionalism, and human rights. I think as the constitutional and Supreme Courts of the OIC member states, we should collaborate and cooperate each other in order to promote these very essential ideas of democracy, rule of law, and human rights. 3 years ago, we met in Istanbul and declared a declaration called Istanbul Declaration, wishing to establish a conference or an association of constitutional courts and Supreme Courts of the OIC member and observer states. And today, just a few minutes ago, we, as the working committee of this conference, decided to establish and to name and also to form the conference. Such a conference will be a significant development for all of the courts, constitutional courts and Supreme Courts of the OIC member states.
Oh, those are definitely beautiful moments that we'll always remember from our conference in Bandung. Congratulations again. And now, ladies and gentlemen, to put a conclusion to the entire conference, allow me with deep honor to invite the closing remarks from the Deputy Chief Justice of the Constitutional Court of the Republic of Indonesia. Please give a big, warm round of applause for His Excellency Aswanto.
Forgive me, let me take off the mask. Bismillahirrahmanirrahim.
Good tidings to us all. Honorable Chief Justice of the Constitutional Court of Republic of Indonesia, and ladies and gentlemen justices, Chief Justices, Presidents of Constitutional Courts, Supreme Courts, Constitutional Councils, and equivalent institutions of the OIC member states and observer states. Ladies and gentlemen, thanks be to God. We offer thanks to the presence of God Almighty for His grace, guidance, and blessings, as well as many ease and conveniences that continually are poured to us all, so that the second conference of the Judicial Conference of Constitutional and Supreme Courts and Councils of OIC member states and observer states were able to be organized and have produced a shared commitment, as we can find in the Bandung Declaration. I would like to offer my thanks and appreciation to all of the countries that have participated in this conference and members of the working committee who took the time to participate in the activities in person. In this two-day conference, we have heard many presentations from friendly countries and obtained a perspective on how judiciaries, especially in Muslim countries, contribute to the protection, promotion, and enforcement of human rights, and as well as various constitutionalism ideas that are in line with Islam. The protection and promotion of human rights have been the commitment of the Islamic world. Those who are part of the OIC, and this is reflected in the Cairo Declaration of 1990. This declaration shows that the contents of the Islamic teachings based on the Quran and the Hadith places humans as a noble creature and preserve this nobility by giving due regard and appreciation to the values of humanity, to preservation and respect of rights, without regard to race, groupings, ethnicities, religions, or belief. This shows the compatibility of the values of Islam as rahmatan lil alamin and the principles of human rights that are universal. This Islam, which is a blessing for all nature, shows the inclusivity of the values contained in it to the universal aspects of human rights and development of the thinking of law and justice in every stage of civilization. Allow me to express to this distinguished forum a little bit about the divine spirit that is reflected in the Republic of Indonesia's Constitution, the Constitution of 1945. Its third paragraph of the preamble reads, "With the blessing and grace of God Almighty, and driven by the lofty desire to have an independent nationality, the Indonesian people therefore declares its independence." This paragraph starts with a recognition of the might and omnipotence of God Almighty and the principle of divinity in the life of the nation and the state. This value can also be found in other parts of the preamble of the Constitution, which is in the fourth paragraph. In the fourth paragraph, we can find the formulation of Pancasila, or the 5 principles or 5 pillars, the first of which states the belief in God. This value that is contained in the preamble of the Constitution of 1945 provides the foundation and the reference constitutionally to understand that the values of divinity is an integral element of the Republic of Indonesia's Constitution. Meanwhile, our togetherness in this forum to talk about issues of human rights and constitutionalism based on Islamic values is an effort to realize the commitment to enforce human rights and to also color and contribute to development of the global thinking on constitutionalism, as well as the effort to bridge the views and to correct the error in the views regarding compatibility between the values of Islam and human rights. Ladies and gentlemen, the conference is a continuation of the first conference, which was held in Istanbul, Turkey, the one that produced the Istanbul Declaration, mandating Indonesia to host the second conference. This conference is an intellectual endeavor to share and exchange experience and perspectives in the enforcement of law and human rights based on the experiences of many judicial bodies and their considerations in issues of human rights. By sharing that understanding and best practices, we hope that the understanding of the inclusivity of the Islamic values to the principles of human rights and constitutionalism can be more accepted and absorbed at a global level. Indonesia, as the country with the largest Muslim population, stands and moves together with its friendly countries to realize this space of dialogue continuously. The journey of the Constitutional Court of the Republic of Indonesia in bearing its tasks and authorities constitutionally has also allowed it to decide cases of the nexus between the values of religion and human rights. The compatibility and the harmony of values can always be found, and the discussion that we have just gone through can continue to enrich the perspective, to find references to decide constitutional issues in the future. Also, as a form of our shared movement, through this conference we have agreed on the Bandung Declaration, which is a historical landmark, which is the birth of the Conference of Constitutional Jurisdictions of OIC member states, or CCJ-OIC. This official platform is a forum to discuss, dialogue, share thinking and experiences, as well as best practices of OIC member states in resolving constitutional cases related to the protection of human rights with a regular and continuous discussion. To conclude, again, I would like to express my thanks to all friendly countries and all of the audience for your participation in this conference. May God continue to provide us with the facility and ease to see each other again in subsequent conferences. Thank you, and may peace be upon you.
Thank you very much, Your Excellency Aswanto. Ladies and gentlemen, we have come to the end of the second conference of the Judicial Conference of Constitutional and Supreme Court Councils of the OIC Member Observer States, J-OIC. On behalf of the organizing committee, we would like to thank you all from the bottom of our hearts, both here in Bandung and out there joining us from different parts of the world, from different time zones. Thank you so very much. We sincerely wish that you're all here with us here in Bandung, but unfortunately the pandemic is still kicking in high gear and we are keeping everyone safe. And thus from Bandung we are sending you all our best wishes, and may we come out stronger at the other side of this pandemic. And now, ladies and gentlemen, finally I'm Rahmat Idris. It's been a pleasure and an honor. Thank you so much. See you in 2022. Goodbye.